The UN Convention on the Law of the Sea provides a compulsory and binding framework for the peaceful settlement of disputes. If the parties have a dispute with respect of interpretation or application of the Convention, the compulsory dispute settlement is triggered. However, not every maritime dispute can be resolved this way. Professor Zhang said the dispute between the Philippines and China is one of these instances.
It's these three hurdles. First of all, is this a dispute under the UN Convention on the Law of the Sea? Second, have the parties agreed to resolve it in another way? And third, is this dispute excluded from the dispute settlement system of the Convention? And in none of the three hurdles, let's say, for none of the three hurdles do I find the answers of the tribunal fully convincing.
According to the paper, the dispute between the Philippines and China is clearly over sovereignty over maritime features in the South China Sea, which do not fall within the scope of the Convention.
First major issue is that the dispute is not necessarily a dispute under the UN Convention on the Law of the Sea, though it has been presented as such. So the way that the Philippines presented the case to the tribunal is very smart. They said, we don't want you to tell us anything about who owns the particular features. We just want to know what these particular features are. But of course, that is an artificial separation of the real issue. The real issue in dispute is who owns the particular feature, and so who gets the benefits of whatever zones that feature generates. And a sovereignty dispute is not a dispute under the UN Convention on the Law of the Sea.
China and the Philippines have reached agreement to settle their dispute in the South China Sea through friendly consultations and negotiation. This would have the effect of depriving the tribunal of jurisdiction over this dispute.
Now, China, even though it did not appear before the tribunal, has made the case that they have agreed with the Philippines, as well as with other states, to resolve disputes with respect to South China Sea by negotiation. And in fact, there are a couple of documents that were presented to the tribunal, which the tribunal considered, that seemed to point in that direction. But the way the tribunal dealt with them, in my view, was slightly unsatisfactory. The dispute settlement system of the Convention allows states to exclude certain matters from dispute settlement. And China has has exercised its right to exclude all the matters that it can exclude under the Convention from the jurisdiction of an arbitral tribunal or any tribunal under the Convention.
The South China Sea issue has become increasingly complicated and serious, and from this discussion, we can see the limitations of this compulsory dispute settlement system under the Convention in regarding to resolve the issue of South China Sea. Zhang, CCTV, Oxford.